Hello, and welcome to the latest episode of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners re-domesticate out of volatile legal and tax environments to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, I am reviewing a recent report by Erica York, writing for the Tax Foundation, entitled Purchasing Power: The Real Value of $100 by Metropolitan Area. I will then conclude by explaining how owners of small and medium-sized businesses can leverage federal and state law to their advantage to relocate their existing LLC or corporation to a new state the right way, while keeping their existing federal employer identification number, contracts, bank accounts, credit history, and track record intact. But first, a brief introduction. My name is Professor Chad Daniel Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, together with a bachelor's degree in accounting and a master's degree in taxation, in addition to 13 professional licenses and certifications spanning accounting, tax, audit, financial planning, and of course, the law. My firm website is www.cummings.law. Now, on to business. The Tax Foundation recently published a map showing what $100 actually buys in real purchasing power in different parts of the country. The data come from the Bureau of Economic Analysis, which tracks price levels by metro area, and the most recent numbers are worth looking at if you are thinking about potentially relocating yourself and your business. Here is the short version. Prices are not the same everywhere, and the gap is bigger than most people would assume. Further, the gap is widening. In the Bay Area, for example, $100 buys you about $84.58 worth of goods and services. Further south in LA, it is $86.61. San Jose is $88.66. Now let's jump over to the other coast. In the New York metropolitan area, which stretches into New Jersey and Pennsylvania, that figure comes in at $88.91. Seattle is right there with them. 6 of the 10 most expensive metropolitan areas in the United States are in California, and that should come as no surprise to you. Now, look at where that same $100 stretches further. In the Houston, Texas area, it is worth $99.78. In Austin, Texas, $100 equals $102.44 in real purchasing power. In San Antonio, about an hour to an hour and a half south of Austin, that number is even more impressive at $106.69. In Jacksonville, Florida, $100 equates to $100.79. In Lakeland, Florida, $102.70. Pensacola, $104.65. Outside the metro areas in Florida, it's even higher at $107, and outside the metro areas in Texas, a whopping $114.77. Is it any wonder that businesses, small and large, are flocking out of New York and out of California to Texas and Florida? I think not. Now, run the comparison head to head. $100 in San Francisco buys $84 and a change, but that same $100 in the rural parts of Texas buys nearly $115. That is a 35% difference in what your money does before we even start talking about taxes. And this is the part that matters. The purchasing power gap added to the tax gap. Well, those are 2 separate things, but they stack. California, as we have reported at length in earlier editions of Legal Bites, has the highest top marginal income tax rate in the United States. New York and New Jersey are not far behind. Meanwhile, Florida and Texas have no personal income tax whatsoever, and most small and medium-sized businesses in Florida and Texas pay no entity-level income tax. So an owner in California pays the state first, then spends what is left in a market where their dollar has less purchasing power. Meanwhile, an owner in Texas or Florida keeps the state's share that stays in their own pocket and spends it where prices are lower and purchasing power is higher. You get hit twice on one side and helped twice on the other. Now, there is a version of this argument that says high cost cities are worth the premium because of what they offer. Well, that's a matter of opinion. I've been to New York and the Bay Area recently, and I can't say I'd like to live in either one, but you know what? That's personal preference. And that may be fair enough for some businesses. But if your company can operate anywhere, and many can, you are paying that premium for nothing. If you are a digital nomad and you're residing abroad in South America or Europe or Southeast Asia, it makes absolutely no sense to leave your company domiciled back in a high tax state like California or New York. Now, for a pass through entity, and by the way, according to the Federal Internal Revenue Service, more than 95% of small and medium sized businesses in the United States are pass through entities. So this likely applies to you. This difference lands directly on your personal federal Form 1040. Tax Foundation data indicate the average business that moves to a state without an income tax keeps more than $12,500 per year. And in some cases, that savings can reach 6 or even 7 figures. Remember, that is an annual recurring savings that stays in your pocket. Same revenue, same work, different result depending on which state is named on your organizational paperwork. Now, with this context in mind, redomestication is the lesser known legal process of transferring a company's state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income tax consequences, but only when performed with the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When performed by a competent professional, and that is an important caveat, the company retains its existing federal employer identification number, contracts, credit history, and bank accounts. That is to say, there is zero operational or financial downtime, but only if you get it right the first time. That is why it is imperative to work with a credentialed, experienced professional and save the DIY for home improvement, or better yet, spend your time running your business. I have successfully completed redomestications from all 50 states. Yes, that includes California. Yes, that includes New York. And for limited liability companies, partnerships, subchapter S entities, and subchapter C corporations. So if someone is telling you it cannot be done, what they are really telling you in so many words is that they do not know how to do it. Now, foreign entity registration is not the same thing as redomestication, because a foreign entity registration, also referenced as foreign qualification, does not, repeat, not change the company's domicile. It keeps the entity in the former state indefinitely and merely adds yet another layer of compliance and tax obligations in the new state, thereby leaving you anchored to the place you thought you were leaving. Meanwhile, a traditional merger, which is still not the same thing as redomestication, creates a new separate entity in the destination state, may and often does require the issuance of a new federal employer identification number, and can trigger serious tax consequences, particularly when performed by an amateur. Finally, dissolution should not enter the conversation at all, because dissolution terminates the company. Dissolution is the legal equivalent of administering a lethal injection to your business. Dissolution is a going out of business maneuver, not a relocation mechanism. Dissolution is often a taxable event and, to make matters worse, can expose the owners of the company to unlimited personal, yes, you heard me correctly, personal, joint and several liability for the company's liabilities known and unknown. That is a one-way ticket to bankruptcyville for some businesses. That is because the so-called veil of liability protection no longer exists, because the company no longer exists. Simple logic. If you think dissolution is a shrewd cost-saving option, you are in for a rude awakening. And if you have a so-called professional advising dissolution as a relocation strategy, please seek better advice before you make a costly and perhaps irreversible mistake. Redomestication, listen, this part's really important, so pay attention. Redomestication, when paired with the change of personal residency and, not or, and a reduction or outright cessation of business operations in that former state, can reduce or even eliminate state tax nexus exposure there for the entity and its owners. Don't take my word for it, ask your CPA. And if you get a blank stare from your CPA, well, it might be time for a change. Now is the time to consider acting, as the various state legislatures are actively considering changes to their respective laws to hinder or even eliminate the possibility of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation to a new state, please utilize the link in the description or in the bio for more information on this intricate process and to schedule time for you and I to speak one-on-one about your specific scenario. Again, my name is Chad Daniel Cummings of the firm Cummings and Cummings Law, and I hope that you found this information informative. As always, the information in this presentation, like all of my presentations, is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice definitionally must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on these topics, please visit my firm website at www.cummings.law, not .com, but .law to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.